The ink was barely dry on the president's health care reform law when 13 Republican state attorney generals filed suit to challenge it, a suit that would eventually include more than half the states in the country, and it led to today's Supreme Court ruling. Connecticut Democratic Senator Richard Blumenthal joins me now. He served 5 terms as his state's attorney general, was a law clerk to Justice Harry Blackmun, and later argued 4 cases before the Supreme Court. Senator Blumenthal, thanks for coming. I couldn't think of a better person to talk to about a couple things that I've been wanting to talk about before this started. First, explain to folks, put on your attorney general hat, and explain to folks why these states' attorneys general, and all of them were Republican, it was a partisan thing on that front, but what gave them the constitutional grounds to challenge this?
The constitutional grounds to challenge have to do, in their view, with states' rights and powers that would be implicated, in fact impeded, in their view, by this law. I disagree with that view. I don't think that the rights or powers of any state are degraded or diminished in any way by this law. And they also raise the same issues as the other plaintiffs did about the Commerce Clause and the excessive regulation of individuals. But I think at the core, their case has to do with states' rights and state powers. And I'm a strong believer in states' rights, but I also think those fundamental reforms, for example, enabling young people to stay on their parents' policy until the age of 26, stopping discrimination against people because they have pre-existing conditions, or dropping them because they get sick, or billing them into bankruptcy because of the lifetime or annual caps on limits. Those are all core reforms that in no way implicate state powers or rights. And so I disagreed, and I declined to join that effort to strike down the law.
Was there ever, when you look at this, do you feel like at any part of the law, does it go up to the line in your view of challenging states' rights? Was it ever a close call for you?
For me, no, never a close call. I think that the challenge, let's be absolutely blunt here, was more political than legal in its driving force. And I think we've seen that because the core questions now for the court have more to do with the Commerce Clause and imposing some limiting principle on the individual mandate. I think that's the issue most in contention. Can the government require people to buy a product? And again, we can go into the legal issues there, but I think the state's challenge was more political than legal.
All right, 2 other questions that I feel like you have a unique expertise on. One has to do, state of Connecticut, big state with a lot of insurance companies headquartered in the state of Connecticut. Your expectation, if the mandate is struck down, is there any other response than raising rates to extraordinary levels for the insurance companies in order to keep the other parts of the law, if they are forced to deal with the pre-existing condition issue and these other aspects of the law, that unlimited caps, etc.? Is there any other response other than raising rates?
There are other responses, and I can commit to seeking those responses, but the insurance companies, to their credit, have indicated they'll keep many of these core reforms, but
without
at the
raising
same time,
rates?
And my hope is without raising rates, because, for example, just to take one, preventive care ultimately is in their long-term financial and economic interests. Healthcare delivery costs have to be brought down, but at the same time, I am going to be fighting against any effort to impose higher premiums at a time when our economy and our small businesses can least afford them, and the insurance companies have been doing quite well and should be held to those core reforms, like not discriminating against people with pre-existing conditions or dropping them when they get sick. Other kinds of reforms, including keeping the 23,000 young people who are now on their parents' policies, millions across the country who can stay on those policies until the age of 26. Those kinds of benefits for people, I think, are in the insurers' interest, and the enlightened ones are adopting them.
All right, now finally put your former clerk hat on. How does the most important, perhaps, ruling with huge political policy ramifications in perhaps a century not leak out? What is it that happens with you clerks that keep you from leaking any of this stuff?
Fear. Clear fear. And the sense of, more seriously, the sense of an ethos a kind of unwritten rule that it would be so damaging to the court for there to be any premature disclosure. And I think that sense of integrity pervades the court, from the clerks to the secretarial staff, the clerical staff, to the justices themselves, as much as they may disagree. And there are strong disagreements, needless to say, some of them quite emotional. Right. The integrity of the court and its credibility is really at stake in the avoidance of premature disclosure. And by the way, I think also in the decision itself, the credibility and reputational value of the court is very much in play.
Well, it's one of the more remarkable sidebars. If there is one branch of government that we know doesn't leak. Anyway, Senator Richard Blumenthal, Democrat from Connecticut, thanks for coming on this morning.
Thank you.